Hello friends, how are you? I hope you all will be well. Today I am discussing two important questions which were before Honorable Punjab and Haryana High Court. These two questions are whether appeal in terms of Section 29 of the DB Act is maintainable against interim order passed by magistrate under Section 23 of the DB Act. Second question is whether appellate court, while hearing appeal under Section 29 of the DB Act, can pass interim orders. The case title which I am discussing is Bhanu Kiran versus Rahul Khosla and others, and the quorum is Honorable Justice Jagmohan Bansal. Now coming to the facts of the case, the petitioner wife filed a petition under Section 12 of the DB Act before magistrate seeking maintenance and other leaves. The petitioner further filed an application under Section 23 of the DB Act for interim maintenance. The magistrate, while order dated 22 September 2022, directed the respondent husband to pay a sum of rupees 60,000 as interim maintenance to the petitioner and minor child. The respondent husband filed an appeal under Section 29 of the DB Act before the Sessions Court seeking setting aside of the interim order passed by the magistrate. The Session Court, while impugned order dated 18 October 2022, partially stayed operation of the order granting interim maintenance by the magistrate and directed the respondent husband to pay rupees 15,000 per month as interim maintenance till final disposal of the case. The petitioner challenged the impugned order of the Session Court on the ground that the appeal under Section 29 of the DB Act can be filed against only final order and not against interim order passed in terms of the Section 23 of the DB Act. Listening to this, the Punjab and Haryana High Court held that an appeal under Section 29 of the Domestic Violence Act is maintainable against interim order passed by magistrate under Section 23 of the DV Act, and appellate court has power to pass interim order under Section 29 of the DV Act. The single honorable judge bench of Justice Jagmohan Bansal further observed that the appellate court may or may not exercise power to pass interim order. However, if it is held that appellate court in terms of Section 29 has no power to pass interim order, it would amount to curtailing the power of the appellate court. It seems to be contrary to the settled canons of law that appellate authority or court, unless specifically worded, can exercise all those powers which are vested in subordinate authority. It cannot be approved that magistrate has power to pass interim order, however appellate court has no power to pass interim order. It was further contended by the petitioner that appellate court, in the absence of specific power under Section 29 of the DV Act, has no power to stay operation of the impugned order passed by the magistrate. The counsel for the respondent husband argued that the expression order used in Section 29 of the DV Act includes interim order, and power to hear appeals includes power to pass interim order by the appellate court. Now, what are the court's observations? There were two questions for consideration before the court. First one was whether appeal in terms of Section 29 of the DB Act is maintainable against interim order passed by the magistrate under Section 23 of the DB Act. Second was whether appellate court, while hearing appeal under Section 29 of the DB Act, can pass interim orders. While answering the first question, the court observed that DB Act is a special statute, and from the reading of the Section 28 and 29, it is quite evident that provisions of the CRPC are not applicable to appeal against orders passed by the magistrate under the DB Act. The court further observed that legislature, wheresoever did not intend to provide for appeal against interim order, it had specifically provided therein. The court further held, in case of DV Act, there is provision for passing interim order as well as in appeals. However, there is no specific inhibition for filing appeal against interim order. Accordingly, the court held that an appeal against interim order passed under Section 23 of the DV Act is maintainable before the Session Court under Section 29 of the DV Act. While answering the second question, the court observed that courts, tribunals are always possessed with incidental and ancillary powers which are necessary to adjudicate the dispute. The court further held, if it is held that under Section 29, appellate court is not bestowed with power to pass interim order against interim order because there is no specific power under Section 29, the appellate court will be denuded from power to pass interim order even against final order because there is no such specific power to final order. Existence of power and use of power are two different dimensions of the legal jurisprudence. Accordingly, the court held that appellate court, while exercising power under Section 29 of the DB Act, has power to pass interim order. However, the court directed the Session Court to decide the appeal within 2 months. Thanks for watching. See you again. God bless. I further request you to guide me for my next topic, which you feel to be the need of today. Till then, bye bye. God bless. See you again.